my understanding, and please correct me if I'm wrong, is that it is the Senate and only the Senate, not the President of the United States, that has the capability to determine when the Senate is in recess. Is that your understanding?
Yes, that's my understanding based on the text of the Constitution, based on the history of the Constitution, its original understanding, and on custom and practice as it's evolved over the last 2 centuries. We are expressly given the power, as is the House, to determine the rules for our own procedure and internal governance, and we do that.
So the President is relying, in making this recess appointment, on the Office of Legal Counsel's justification in a memo that they issued. And their memo essentially said that the OLC effectively asserts that the President may unilaterally determine if and when the Senate is in recess for purposes of exercising his recess appointment power. So my read is that the President is looking at his legal counsel's opinion that says he can decide when the Senate is in recess. However, there's clear precedent that states only the Senate has that authority. So that's problem number one with this process. The other 2 points I'd like to make is that back in 1993, during the Clinton administration, the Department of Justice filed a legal brief in Federal court for the District of Columbia, arguing that unless a recess lasted for 3 days, a President could not make an appointment more than 3 days. The third point I'd make is in April of 2010, then Solicitor General Elena Kagan acknowledged before the United States Supreme Court that, quote, the Senate may act to foreclose the President's recess appointment power by declining to recess for more than 2 or 3 days at a time over a lengthy period. Presidents have not in recent decades made recess appointments during intra-session recesses lasting fewer than 3 days. So there is most recent opinions and precedent set by those who would likely support the philosophies of this President, who have acknowledged that what this President is doing is wrong. And to speak to what the gentleman from Virginia mentioned, is that this should be about appropriate powers of the executive branch. It should not be about Republican or Democratic philosophies. It should be about the country and what is good for the country. And I believe that all of us in the legislative body as well as in the executive need to adhere to the precedents and the laws and the rules that we have established. And without doing that, these bodies cannot gain greater credibility with the country. And I would submit that it makes sense for the President of the United States to acknowledge in this circumstance he erred and that he should resolve it to reinstate the faith in the process that we have.
If I can respond to that, thank you very much, Congressman. Yes, I share your concerns, and I've reviewed the Office of Legal Counsel's 23-page single-spaced memorandum. It is well written. It's well researched in the sense that it points out the precedents, but it reaches the wrong conclusion, and it reaches a conclusion that is at odds with the very precedents to which you referred, and to the very logical positions to which you referred. And as I'm responding to that, I'd like also to respond simultaneously to Congressman Connolly's point, because I think they kind of lead to the same conclusion here. I understand and I share the frustration that so many Americans have expressed over the fact that there are delays at times, sometimes long delays, sometimes delays that don't get resolved until after that Congress is over or after that President is no longer in power. That is frustrating, and it's especially frustrating to those whose names are on the line to be confirmed. As frustrating as this is, constitutional government is necessarily, by its very nature, frustrating. It was designed to be frustrating in the sense that it was designed to make sure that it wasn't so efficient that we just passed laws really quickly. Efficiency doesn't always lead to liberty, and frequently it leads to exactly the opposite position. So the fact that this process is frustrating, the fact that there are at times delays, the fact that the delay has sometimes been abused, even though it's the prerogative of the Senate to do that, does not and cannot ever justify circumventing the Constitution and just saying, this is really necessary, this is really important, I'm therefore going to do this. At every turn, when we've tried that in this country, it hasn't ended well. And I'm determined not to allow that to happen here. I'm not about to stand idly by as this precedent gets established, knowing full well that it could, and unless we do something about it, it will be abused in the future, not just by Democratic presidents, but by Republican presidents.